Hello, this is Tom Azoni. I'm with Secrest Wardle, and today I want to talk with you about the open and obvious hazard rule in Michigan in premises liability cases. This series originally began in 2014, and at that time I presented a pretty detailed summary of the entire topic, and it's both now in webinar form that we've recorded and saved, and it's also contained in our handbook on premises liability. So if you want either of those things, you can contact either Mark Masters or me, and the number's on the screen, or you can email us and we'll be sure to get that to you. It's free for the asking, and if I say so myself, it's a pretty accurate summary of the law. The plan for today then is not to go over that entire spectrum of the law and repeat what I did in 2014, but to discuss in a little deeper detail some of the things that are ongoing now in the law that we're seeing in the last year. Before we get to that, however, I want to talk to you just for a moment about this issue of published and unpublished cases in Michigan, because it's important as we go forward that you have a good understanding of what that's about. In my chapter on this topic of open and obvious hazards, I tried to concentrate on published cases to the extent possible. However, you'll see when you read the chapter that there are a number of unpublished cases that are referenced, and the reason is because of the volume of unpublished cases issued by the Michigan Court of Appeals. Now, for those of you who are unfamiliar with Michigan law, the Court of Appeals publishes cases each day, and they're all contained in the Michigan State Bar e-journal. And they're either marked published or unpublished. However, they're all published. You can read all of the unpublished cases and all of the published cases, and they're published equally. But some are marked published and some are marked unpublished. The ones marked published are binding. Their decision is binding on the bench and the bar. Unpublished cases are not. They're intended to be informational, a sort of a peek inside the thinking of the Court of Appeals on any given topic. However, any attorney worth his salt who finds an unpublished case that supports his or her view of the file attaches that decision to a brief and tries to persuade the Court of Appeals, or excuse me, tries to persuade the trial judge that that's good law. The Supreme Court has now issued a rule attempting to restrict the use of unpublished cases. That rule went into effect in May of this year, so last month. Basically, the rule says that if you're going to cite an unpublished decision, you have to explain in your brief why it is you believe you need to cite that decision. The purpose is to restrict their use. So the decisions that are unpublished in the chapter summary that I wrote may not be as persuasive, as they used to be, and that assumes that trial judges are going to restrict the use of unpublished decisions, and we'll just have to wait and see if they do that. All right, so let's go on and talk about this topic. I want to start out with a photograph I used back in 2014 because to me this really makes clear the open and obvious hazard rule. This is a front porch of my partner, Mark Masters. It was his house, and he was building a new porch at the time. And you'll see here he was at the stage where he had knocked out the old porch. And, being a careful homeowner, he put yellow hazard tape around the sites to let people know that the area was dangerous and to stay away. But if you look carefully at the front door, what do you see? You see a flyer there, and he told me that that was a pizza coupon. So the person who is extremely diligent at doing their job came upon his house, saw the yellow tape, must have stepped over it, stepped around or over these broken concrete blocks, and dutifully left the coupon there on the front door. And so the question is, well, if that person had fallen in the scope of that attempt to leave the coupon there, could that person have sued mark under one of two theories. One, that you were negligent in failing to secure the job site in a way that was not dangerous to invitees, and someone delivering a business coupon is a business invitee. Or secondly, were you negligent in failing to warn business invitees of the potential hazard of what lies before them? And the answer to that question is no. No one could sue him. And the reason is Lugo versus Ameritech from 2001. And you'll see the Michigan Supreme Court ruled there that if dangers are either known or are so obvious that someone would be reasonably expected to discover them, then the person who owns or maintains the premises, owns or possesses, I should say, the premises, has no duty to either protect or warn the invitee. And then there's some exceptions, but that's the general rule. And the policy behind that rule is that people should be responsible for their own actions. That person who delivered that coupon had a choice to make. And in Michigan, if you make a choice that says, I'm going to encounter something dangerous, even though I can see it's dangerous with my own eyes, then you take that risk on yourself. And if something goes wrong when you've made a decision like that, the result is on you and not the property owner. That's the basic point of the law. It was made finer a bit earlier by the Court of Appeals, and this is still good law, the Novotny case. I won't talk about the case facts in detail. We've done that. So what you just need to remember is that in the open and obvious hazard arena, the question is not what the plaintiff saw or what the plaintiff didn't see. It's what would an average person with ordinary intelligence have seen? Would a reasonable man have been able to see and avoid the hazard? And if so, then you're out of luck. So that's the question of each case involving a premises liability claim. It's the Novotny question. Would an average person with ordinary intelligence have been able to discover the danger upon casual inspection? And that's the key phrase. Upon casual inspection, it's not just enough that the person be able to see it. You should be able to see hazards after you've inspected for them. Well, that's quite a high hurdle for plaintiffs. So there's a great impetus for plaintiff attorneys to find a way around this rule. And they're doing it in the last year more and more often by trying to plead around the open and obvious hazard rule. When I say plead around it, I'm talking about how they draft their complaints. And they're doing it in a way to call their cause of action something other than a premises liability claim. Because remember, this defense applies only to premises liability claim. And so what is a premises liability claim? Well, what are premises? The premises is the land and things that are permanently attached to the land. And so what's a premises liability claim? It's some defect in the premises. So that Lugo case was a defect in the parking lot. So the parking lot's part of the land, and the defect was a pothole. In Mark Masters' picture, what is the premises? It's that porch is permanently attached to the house, which is permanently all attached to the land. That's as a premises liability claim if it had been brought. So plaintiff attorneys now, more and more often, are attempting to call their cause of action something else. And what they're calling it is a general negligence claim, not a premises liability claim. And a general negligence claim does not have to do with a defect in the premises. It has to do with someone's negligent conduct. All right, so let me give you an example of that. Well, this is a lousy picture, but it'll serve its purpose. In a case called Kwiatkowski versus Coachlight Estates, the plaintiff was in a mobile home park. So imagine this is in a mobile home park. And imagine if you will, that door that you see that's open there had a door that opened outward onto a very narrow porch. And in that case, the plaintiff, who had been to this mobile home many times before, stood on the narrow porch, knocked on the door, and the homeowner came to the door, opened the door, and it opened outward into the plaintiff, knocked him off the stoop. He fell and was injured. And so he sued the homeowner, claiming, well, that conduct, you knew I was there, you knew the door opened outward, you opened the door anyway, and you put me at risk for injury, and in fact I was injured. You knocked me off the porch and I hurt myself. The defense was, well, wait a minute, it's obvious. You've been here before. You knew that the front porch was narrow. You knew the door opened outward. It was a hazard that was easily avoided upon casual inspection, so that all the Novotny, the question would be answered in favor of the defendant. Would a reasonably careful person have been able to see and avoid the hazard upon casual inspection? The homeowner here said, absolutely. You could have easily avoided this by doing one of a number of things. And so the question for the trial court and then the Court of Appeals was, and then ultimately I'll say this, it ended up in the Supreme Court, was whether or not that's a premises liability claim. And the Supreme Court said, no, it isn't. And the court sided with the plaintiff in that case and found that this really was not a claim involving a defect in the land. Instead, it involved someone's conduct. All right, so the Supreme Court agreed with the plaintiff and said that this was a case where the defendant simply failed to act in a reasonably careful way, that he opened the door, knocked the plaintiff off the stoop, and it didn't matter to the court that all of these things were obvious. So that was one case for the plaintiff, and because it's a Supreme Court case, and of course that's published, all of them are, then that's pretty powerful news to the bench and bar that the Supreme Court has acknowledged the reality of the situation, that there is in fact in Michigan a distinction between a premises liability claim and a general negligence claim, and that this dichotomy between those two claims will determine whether the open and obvious hazard defense will apply. It will not apply in general negligence claims. It will apply in premises liability claim. So now we know that's there. And so that's one of the things you as a claims representative needs to do, is to look at that complaint when it comes in and not just assume, oh, this sounds like something that would have been obvious, but you have to dive deeper into that lawsuit allegation of what happened and why it happened, and make an assessment with your lawyer, of course, as to whether or not this is likely going to be found by the trial judge to be a premises claim or not. And in answering that question, in helping you with your analysis, the issue is, do you see or can you find that what happened was due to something that was associated with the premises, something permanently attached to the property or not, or if it's simply a matter of someone's poor conduct, right? So that's going to be the key. That's what you're looking for when you read the complaint. Are you reading something that tells you that the accident was caused by an event tied to the property itself or not? All right, so the next case is another case that occurred in the last year involving an attempt by the plaintiff to plead around the open and obvious hazard rule. In this case that we're going to talk about, let me find the name, Campo versus Whittemore Inn. The Whittemore Inn apparently is a bar out in the country on the west side of the state, and it had annually races. And in this case, the races were riding lawnmower races. I couldn't find a picture of a riding lawnmower race. This is as close as I could find, but you've got it. So you have riding lawnmowers. They're raced in just some, haphazard racetrack that the bar people set up, to draw customers so they could drink more. And so there was a sort of a flimsy fence around the racetrack, and beyond the fence, people gathered on the grass. And in this area where the plaintiff was seated were railroad ties. And the case facts don't tell us why the railroad ties were, on the ground. Maybe they were to be used as sort of a place to sit, like a bench. But nonetheless, there were railroad ties strewn about. These were known by the plaintiff. So in order to get to the place where the plaintiff was seated to watch the race, she needed to step over these railroad ties, and it was made clear in the case facts that she knew that the railroad ties were there. And so what happened was, the race began, and the riding lawnmowers are going round and round, and two of them collided, and one of them lost control, crashed through the barricade, and was headed toward the plaintiff. She saw it coming, jumped to her feet, jumped backward, but in doing so, tripped over one of the railroad ties and hurt herself. And she sued the bar, claiming that they were negligent in the design of the racetrack, that they were negligent in failing to take reasonable steps to protect their business invitees in the way that they set up this basically flimsy barricade, knowing that these riding lawnmowers were at risk of colliding, losing control, and potentially injuring someone. Well, the bar, of course, filed a motion for summary disposition saying, well, this is a premises liability claim, and here we've got you, plaintiff, because the railroad ties are part of the land. They were secured to the ground, and so the open and obvious hazard rule would clearly apply. And since the plaintiff testified that she knew that the railroad ties were there, the bar was saying, we win. This is a slam dunk. There's nothing to talk about. Well, they lost. And they lost in the Court of Appeals in what I believe is a very poorly written, unpublished decision. This is a great example of why unpublished decisions should not be relied upon. The Court of Appeals basically said, well, you're going to lose, defendant, at least the motion, because the plaintiff has alleged two separate theories of liability in two separate counts. Count one was a premises liability claim, and they said, we agree, she loses that count. Count two, however, they said was a negligent design case, and because they put it in a separate count, and because they called it a negligent design theory, you are going to lose the motion because that's not a premises liability claim. That is a general negligence theory. The problem with that analysis is just because you put something in two separate counts doesn't mean it's so. And there are many Court of Appeals decisions that tell trial judges that when they analyze the language in the complaint, their goal is to determine the true gravamen of the complaint. Their goal is they're charged with the responsibility, that is, of figuring out what is the real cause of action here, that you look beyond the pleadings themselves to figure out what is the true nature of the cause of action. Here, the trial judge and the Court of Appeals didn't do that. They just simply said, oh, you've got two theories, one of them's bad, the other one's good. And they ignored really their responsibility in evaluating the content of pleadings as they're charged to do. And so that's another one for the plaintiff, but I don't think that one is going to be repeated. Just simply putting it in two counts, I don't think that's going to survive as a strategy. It worked once, probably not again. All right, so the next the next case involved Costco Gas Station. And this is a case called Crippen Ski versus Costco. This is another case where the plaintiff tried to plead around the open and obvious hazard rule and lost. in the Costco case, just like you see in this photograph, Costco, well, so you know, Costco has gasoline stations, and their gas is sold, below the general market price. And because they sell their gas cheaply, there's often quite a response, often quite long lines. And in this particular case, Ms. Crippen Ski was getting her gas, got out of her car, was in the process of gassing up when she got behind her vehicle and was pinched by a car behind her that moved up in the queue. And she was pretty badly hurt. So I'm not trying to minimize that when she was pinched, but that was the mechanism. She got pinched between two vehicles because one moved up in line. And the plaintiff sued Costco saying, well, this is a badly designed gas station, and the reason it's badly designed is because you knew that your pricing was going to attract a lot of cars, and that you knew that at the gas pumps people were going to be getting out. So you have cars and people and cars that are moving, people that are moving. You have, basically they're trying to suggest that what you have is chaos at your gas station because of the way you've designed it. And basically what you should have done was to keep the cars away from the gas pumps and let them queue up some distance away and let them come up one at a time when the space was free, the pump was free. The defendant, Costco, said in response, well, this is obvious. The way that our station is set up, getting gas in Michigan and everywhere else is no mystery. In the era of self-service stations, everybody knows how to get gas. Everybody knows how to wait in a queue with their car. And if anything went wrong, it was simply because the one car, got a little too anxious and was negligent in the way that that particular car moved forward without making sure it was safe. It had nothing to do with the way we designed our gas station. And this went to the Court of Appeals, and in that case, the defendant won. And the court did not give a very good rationale as to how they decided in favor of Costco. They simply said, well, this is a case that's not one of design of the gas station. It's simply a case of there are too many cars and too many people. They said that's really a maintenance issue. Therefore, that's a premises claim. And the case was dismissed. They didn't say how that's a premises claim, and I have to tell you that the case really is not well explained, at least the way I read it. I think my view is shared by other attorneys who have read it. What's important for you to understand is the attempt and the analysis is the same kind of analysis that you're going to need to do with your attorneys when you get a lawsuit like this. Is it a design defect? If it is a design defect that's being claimed in your lawsuit, chances are the plaintiff will be able to get past the open and obvious hazard defense. If it's something else, if it's a maintenance issue like the court decided here, or if it's certainly a premises liability theory, then the open and obvious hazard defense will apply. So one other case I want to talk to you about was finally settled, and so let me describe the problem to you. I want you to assume that a plaintiff falls on ice. I also want you to assume that the water from the ice can be traced to a gutter or the lack of a gutter on a building. The plaintiff will assert that the homeowner's negligence or the business owner's negligence in either in installing or maintaining the gutters was the cause of the accident, and therefore the open and obvious hazard defense should not apply. So what are they doing? Well, if it's simply a case where I fell on ice or my client fell on ice in Michigan in winter, they're going to lose that case. The cases now are well settled that if you fall on ice in Michigan and there are winter weather conditions around, snow on the ground, flurries, it's below freezing, any manner of winter weather conditions that are going on at the time, then if someone slips and falls on a particular piece of ice that they claim they didn't see, they're going to lose that case now. There's just too many cases that have said that you who live in Michigan should be aware that at any given time in Michigan, in winter, you may be at risk for slipping on something that was caused by a winter weather condition, and then you're going to lose. So the alternate theory of the plaintiff is to say, well, wait, we're not saying the ice was what caused the plaintiff to fall. That's just one reason why the plaintiff fell. But the real reason that the plaintiff fell was because that building was poorly maintained. That is, the homeowner or business owner allowed those icicles to form. Do you see those icicles there? And that's poor maintenance. The gutter might be plugged. They didn't put some warming device in the gutter. It's just poorly maintained. And it's really that poor maintenance, that conduct on the part of the defendant is what caused the water to melt, get onto the ground, and then refreeze as ice. And so in cases like that, plaintiffs had been winning those cases for a time. And in Kokutis versus Invaders Self Auto Wash, Inc., the Michigan Supreme Court looked at that and said, no, we're not going to accept those kinds of theories any longer. So the court said in that case that, look, if you fall on ice, we don't care where the ice came from. The question for you, the plaintiff, is the ones that, the questions that we've been asking in all the other cases leading up to this. That is, were there winter weather conditions? Did you know that, winter was happening in Michigan? Are you from Michigan? Do you know what happens in Michigan in winter? And do you know that things get slippery? And, if yes, then you lose. So what we no longer have to do now is try to figure out what is the source of the water. Did it really come from the gutter? Did it come from, the grass that melted and refroze? What was the angle of the sidewalk? Could that water have really come from the place where they were saying it came from? And all those kinds of analysis that we used to have to do, we no longer have to do, because that's now the end of those kinds of cases. So that attempt to plead around the open and obvious hazard rule has failed. All right, so then the question is, well, what are the themes to these cases? Well, we now know from the Michigan Supreme Court that there is a real dichotomy between the concept of premises cases versus general negligence cases. This has been acknowledged by the Supreme Court, and so it's here to stay. On the other hand, we know that the courts still try to read between the lines of complaints in order to assess the, quote, true, end of quote, cause of action that's being attempted to be pled. And so all I can tell you here is this area of the law remains unsettled, and that the more you and your attorney can point to a physical defect in the land, the greater the likelihood that the case will be considered a premises liability claim to which the open and obvious hazard defense will apply. The next area of pleading that the plaintiffs are using to try to get around this defense is by calling it a nuisance suit. A nuisance claim has been called the garbage can of Michigan law. If you wish to read about nuisance claims, look in my chapter on it. What I'll just tell you here is that to date, all of the attempts by plaintiff attorneys to get around the open and obvious hazard defense by calling their claim a nuisance claim instead of a negligence claim, where the facts are exactly the same, have failed. And so I don't see that as a significant hurdle. We're seeing that attempt less and less as time goes on, but it's something that you still see occasionally attempted. If you see it in a complaint, look at it and evaluate it the same way you would, had they used the word, premises liability claim. All right, so the next topic concerns one issue that has not yet been resolved by the Court of Appeals, and that is, well, what happens if someone falls in the winter on, let's say, a snowy condition like you see in this photograph, they're claiming is they claim that they didn't fall because of the snow. They fell on something under the snow that they couldn't see. And the reality of that is that there are cases that go both ways on this issue. So let me just explain. The plaintiff might say, for example, well, yeah, I saw the snow and I'm being careful walking on the snow. I've got my winter boots on. I'm doing everything I need to do to be careful on the snow. What I didn't know was that that snow covered a pothole. And it wasn't until I got to that pothole that was the pothole that caused me to lose my balance and fall. There are other cases where the snow was piled higher than you see in this photograph, and the snow pile covered like a parking bumper. The case I had was a significant injury case involving a gas station where the gas station plastic pricing sign, you know, the plastic thing that's up in the sign that advertises the price of the gas, in a storm that had blown off, fallen onto the cement, and was covered by snow. And the plaintiff's claim was, well, it wasn't the snow that caused me to fall. It was that slippery piece of plastic under the snow that I couldn't see. And the claim is by plaintiffs, well, look, this is the open and obvious hazard rule, and if there's something hidden under the snow that is not consistent with winter weather conditions, well, then that rule shouldn't apply. The defense is that, wait a minute, if you live in Michigan, you know that snow covers everything, and that snow can cover any number of hazards, including all of the things we talked about: potholes, parking bumpers, curbs, whatever you like, and that the homeowner, business owner, is not obliged to make the world smooth, flat, and soft for you. If you step on something while walking in winter weather, you are taking on those risks for yourself. And there are cases that are directly opposed to each other in how the courts analyze those fact patterns. And I simply must tell you that the issue remains unresolved at this point in time. But if we disregard the unpublished decisions like the Michigan Supreme Court has directed us to, and look only at the published decisions to date, the defense should win those cases, because the only cases that are currently published that are out there that apply talk about those issues we've spoken about ad nauseum. That is, do you live in Michigan? Were you out in winter weather conditions? If so, you took on this hazard or this risk yourself, and if you encounter a hazard, then it's on you and not the property owner. So that's today's topic. It's been a fairly light year in the open and obvious hazard arena. If you have any questions about any of this, you can give us a call. I think the next screen has our contact information. Well, it has mine. You can call me, you can call Mark Masters, and we'll be happy to either answer your question or get you any of the materials that you like. All right, so thank you for your attention, and hope to talk to you soon.